All right, so Vashawn, I went the speed limit today in the school zone. I didn't go 15, I went exactly 20, and people were passing me. I'm like, excuse me, school zone, school has started. Flashing lights mean it's a school zone.
Get out the mindset of it still.
So you're saying I should not stop my vehicle and stand in the middle of the roadway?
No. Yes.
I'm getting close. I don't know what happened to having crossing guards.
Thanks.
I had crossing guards when I went to elementary school. And there would be a crossing guard ever so often. So if you were an elementary school child walking, nobody was going to take you. There was a crossing guard, like.
That was one of the things that she strived to be when I was in school.
Mhm.
In elementary, you were on good behavior, you really wanted that job.
Okay, am I telling on myself? Vashawn, I was a hall monitor. And I'm like, excuse me. You don't have your hall pass. You better go back to your classroom. All right, I'm going to call the docket. When I call the docket, you need to let me know you're here. Otherwise, I'm going to assume you're not here. The warrant may be issued for your arrest. Joe Lazama is in custody. Patrick Cuellar. Jose Martin Garcia Corona. All right. Eric Mitchell, custody. Lacey Burns Shrunk.
She's shrunk.
Thank you. Francisco Yanez. Francisco Yanez. That's supposed to be recalled. I don't know if Michael told him not to appear or not.
I think he may be in custody because he was arrested on a new offense.
Okay. Could you all check to see if he's in custody? Diego Chavez.
Here you go.
Malik Hatch.
Here you go.
Thank you. June Bright. Jorge Jimenez. Hector Renee Aguilar, custody. Emmanuel Gonzalez. Emmanuel L. Gonzalez. Simon Alexander Garza. Humberto Lira. Rudolfo Brasinho, custody. Antonio Garcia Jr. David Bruce Dondelin. David Bruce Dondelin. Ricardo Reyes. Feliciano Mora. Christina Lozano.
Prison counselor.
Kilo Kimmicker, custody. Sandra Ramon. Sandra Gabriela Ramon. Andrew Thomas Reyes. Kelly Josephine, how do you pronounce the last name? Aguayo. Jacob Edward Aguayo. That doesn't seem like that's Aguayo. Okay. Well, I'm going to pronounce it, the way we do in Louisiana. Jacob Edward Aguero.
There you go.
All right. Oscar Carrillo Hernandez. Thank you. Catherine Marie Flores. Dartarian Daniel Renson. All right, thank you. Brianna Gonzalez, custody, Joshua Albright. Jamal Dixon, custody. Paul Ragsdale, custody. Joshua Craig, custody. I'm sorry, what? I'm sure I did, but I don't know where I put it. Okay, now I remember. Yes, my mind is still a steel trap. David Cortez Jimenez, custody. Samuel Bock, that's 9. Eric Cooper, custody. Jerry McGee, Albert Levine, Joshua Medina, Noah Nelum, Eric Lee Cooper, custody.
No, Anello? It's the virtual.
All right, Noah Nelum. Tony Howe, custody. Alexander Rodriguez, custody. Simon Alexander Garza. Thank you. Jared Wade. Oh, he's by Zoom. Desiree King. All right, Jose Martin Garcia Corona. What? All right, Joseph Martin Garcia Corona. All right, Deputy Laura, he's to be taken into custody. It shows he has an ice hole, so he may not be here. Emmanuel Gonzalez. Second row, you were late. David Dondelon.
We're here, just.
Second row, you were late. Sandra Ramon. Sandra Gabriela Ramon. Custody. Andrew Thomas Reyes. Custody. Kelly Josephine Aguero. Second row, you were late. Jacob Edward Aguero. Jacob Edward Aguero.
Here.
Second row, you were late. This side.
This side. If you're not a defendant, you need to move somewhere else on the second row.
Catherine Marie Flores.
Here.
Second row, you were late. Desiree King. Are they on bond?
That was a probation hearing, so that is before that she was notified.
All right, is there anyone present whose name was not called? All right, state defense. Have you all received the new charge? It was just email.
Judge, I haven't received an email from Marcus this
I
morning.
haven't either. And also, while we're waiting on that, I wanted to point out that there's a typo on page 3. A space between S and annual needs to be removed. It's
Oh,
not-
so let me just tell you about spacing.
Oh.
Because they're doing right line justification, sometimes there's spacing.
Well, it was actual like space. I was able to correct it on mine. I can the red line, but
Mhm.
the other one is that this is a result of the conduct crime, not result of the circumstances surrounding his conduct crime, and it's correct on page 2 in regards to manslaughter, but in regards to the criminally negligent homicide, he's included circumstances surrounding his conduct.
What page are you on? Oh, I see.
Page 4. And Megan, I'm just gonna show you right here and here. And then Your Honor, if I can just show you those.
Just one moment. Okay.
How do you feel this guy?
Well, I'm not doing it.
What?
I can't go to pairing some of the others.
Wish you can. I could go when you're done.
I'm not doing it. Who's good with the G? I know what you're doing. Right now, I should just, I'm just going to the charge. I would appreciate it if you guys could.
You know, we're gonna harass you right now. At least I made you laugh.
Yeah.
You're welcome. Christine's gonna stretch you out. Christine's gonna stretch you out. She's really good at it.
All right, here you are. All right, and then are you aware what she wants removed?
I am aware, but I think it's correct in response to the criminally negligent homicide because the mental state is different. And so it's regarding that he ought to be aware of the circumstances surrounding. And so it's correct in that way on page 4 for that respect. And it is correct for the manslaughter.
Okay, so what I'll do is I'll hear you all arguments. I'm waiting for him to bring me the rest of the charge. And then it will be emailed to you and I'll hear everybody's argument.
Okay.
Thank you. Oh my gosh. Well, she enjoyed it. However, her mom asked her the question that maybe you're not supposed to ask. You want to go to school today? No, but I know, you guys were right. I know that she is going to be excited once she gets used to everything. Yeah, so I'm gonna go with that. I'm going with that.
Yeah. All right, if I see the. Okay, so if anyone has somebody who is not in custody, we can take up your matter. All right, thank you.
It doesn't have it in the standard. This is the pattern charge.
Senator Ramon?
It's just striking. Yeah, you strike the circumstances exist. Or. And then strike it. Yeah.
With respect to the result.
Yeah. So, yeah. You don't care what the two, but the two should stay in. Oh, wait, maybe not. Respect the result.
Okay.
Yeah.
I mean, I don't, on what she's talking about, striking that the circumstances exist, I don't object to that, that's fine.
Okay, all right, so Marcus has that. So that will be stricken. All right, so Malik Catch.
What portion of it comes out?
So what is going on? Oh, no, that's in mine. What is going on?
Or to the elements and they're there for the assessment. That's the problem. It's all into the bottom street gas. But then the street with assessment, like have now decided to send him back to the municipality.
I'm sorry about my name. Yeah.
Right. So now Judge, I really just. Let's help us move this forward. Mr. Hatch is a very good candidate for either of the plans. He's already, they're going to. Yeah.
I just want to say. Don't follow the street report like outline. It's not accepted. We'll go from there. Something is gonna be done before the month was out. All right, so just have a seat.
I know you're going to twist this.
Oh, we are, you know what? I'm gonna just tell everybody, we are all. There's nothing worse when somebody tells you. And I'm so big for this, and I'm not, you know, so everybody.
Remain the hearing is criminally with respect to the result of this going.
All right, and Herman is on his way down with regards to the Veterans Treatment Court. Oh, you're welcome. Yes.
Judge, are you regarding? What name?
Malik Hatch.
Yes, Judge, he was not accepted in the treatment court. I have an outcome. I gave it.
I sent it back to the mental health.
Okay.
These are-
So Herman, you're saying there's no nexus? All right, who's here on Emmanuel Gonzalez? Good morning.
That's not.
All right, today's your plea deadline date. Is this going to be a jury trial or has he reached an agreement?
Jury.
All right, how long is this trial going to take? And is it criminal trial division or family violence?
Family violence.
How long is this trial going to take?
2 or 3 days probably.
All right, Norma, 2 days. We'll see. All right, your jury trial date will be October 7th. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll have to plea open to the court. Do you understand? All right, and let me see. I have the acknowledgement of discovery. There's no other outstanding discovery. All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused. Just have a seat. Your attorney will bring the reset form to you. Thank you. You're welcome. All right, state on the Kim Micker, he's in the hospital at the jail. So
Okay.
we're gonna reset it.
Great, thank you.
Norma, I need a 3-week reset on Kim Micker. Okay.
Yeah, right now, I'm doing close and that. And then
Yeah, yeah, nothing probably. If you want to sign off, you don't have to see. That's one thing. She's gonna.
I will do it
So, you know,
today.
So, Megan.
Which page?
It should be this. It's the application. But you can ignore mine.
Oriented to you.
Thank you.
Super confusing.
Oh.
Just.
That's. So you can't argue that unless you do. The dad has not had a current but for his conduct, so if you do believe that another cause. Is the conduct of the victim, is a concurrent. Deficient. And his conduct of the defendant, virulent, then you win. You know, it's guilty.
See, but one of them is that it.
Actually, here's the first. Because there was like a report, it says the defendant's not. Should start by.
Catherine Flores? I'm sorry, you Catherine Flores? All right, just have a seat. I'm just looking up something on the docket first, all right? All right, Miss Flores, if you come up.
Okay, that's fine. It's taking a while to absorb it. Super confusing.
All right, Miss Flores, your attorney is ill. Have you had contact with her? All right, so one or two things, I can reset you. And this attorney will be your attorney, or I can have someone else appointed.
It's all ready to go. Is that where
All
you
right,
are?
just have a seat. We'll make sure that
So they're not
happens.
bringing the
All right,
inmates
thank
out.
you. And Norma, just
I think confusing me is the colons. Is there leanness to these? That's.
Right. And everyone, just give me 5 minutes. Okay. All right, have you all had a chance to review the jury charge?
Yes, Your Honor.
Yes.
All right, we're gonna go on the record. We're going on the record in cause number 2023 CR 8868, State versus Samuel Bock. Could I have parties announced for the record for the state?
Megan Gowan, Jason Garahan for the state.
Jody Sawyers, for the defense, along with Samuel Bock.
All right, have both parties had a chance to review the updated jury charge?
Yes, Your Honor.
State, do you have any objections to the updated charge?
No, Your Honor.
Defense, any objection?
Yes, there is, we were discussing on the criminal causation, I'm sorry, the causation, I think it's, paragraph 4.
Mhm.
That the way, the double colons there is not appropriate. So in the paragraph where it says Samuel Allen Bach colon, so that if you believe that.
So you're
another
asking that the colons be removed?
just that colon, I believe the state's in agreement, putting a period after Bach where that first colon is.
State, are you in agreement to removing the colon
Yes, Your Honor.
and capitalizing the word so?
And we just took that off and put if, but you can do either one. And it started if you believe. But either
All
way,
right.
it doesn't.
Anything else?
Other than, Your Honor, I do not believe there's enough evidence to submit on the element of failure to break. That's the only other thing that I see.
All right, that will be denied. Is there anything else with regards to the charge?
Not from the defense.
All right.
And Your Honor, I apologize. I assume that they did take out, I did not look to verify that the circumstances surrounding the crime and the criminal negligence was taken out.
Yes, that's been removed.
Okay.
All right, can you grab that for me? Oh, no, don't staple yet. All right, if you are you able to make some copies for me? If you make 5 copies of this, thank you. All right, and if you all want to make sure that whatever equipment you need to work is actually working, because sometimes it doesn't work. All right, so on Norma, on Malik Hatch. What we're going to do, can you have his counsel come in? I think she's still in the hallway.
Megan, will you also see if mine will come?
No. I don't know who's.
All right, thank you.
Okay.
All right, so on Mr. Hatch, what we'll do is we'll recall this. Renee, we'll recall it for the 15th.
Okay.
And if he can be here on the 15th, so we can see where we are with that. Are you able to be here? I'll come up for it, sir.
He's back compliant too. Oh. Yeah.
All right, so we're gonna recall you on the 15th at 10, okay? It's Friday. Are you able to be here? All right. Thank you so much for dressing appropriately for court. You always do. Just have a seat. Your attorney's gonna bring you the reset form, okay? All right, thank you. Yes. Thank you. Scott,
Yes, ma'am.
Norma? Oh, Ray. Mhm. So, well, you all need to discuss that. So,
Right, I just wanted to.
okay. All right. So I'll see you all back this afternoon. All right. Thank you so much. All right, everyone, there's going to be closing arguments. Make sure your cell phones are off. There's nothing worse for an attorney when they're in their groove and then all of a sudden somebody's cell phone rings. So turn your cell phones off. Yes. All right, let's bring them in.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, I know you probably noticed that there are more people in the courtroom than you normally see. It's because this is my morning docket. So the other persons that you see in the courtroom have absolutely nothing to do with this case, so please disregard. All right, what I'm going to do is I'm going to read to you what is called the charge of the court. It's the jury charge. You do not have to memorize it. You'll be given the original when you begin your deliberations. Charge of the court. Members of the jury, the defendant Samuel Allen Bock stands charged by indictment with the committed on or about the 25th day of January 2022 in Bexar County, Texas. To this charge, the defendant has pled not guilty. 1. Our law provides that a person commits the offense of manslaughter if the person recklessly causes the death of an individual. 2. Individual means a human being who is alive. 3. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4. A person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. Therefore, you cannot find the defendant, Samuel Allen Bock, guilty unless you believe beyond a reasonable doubt that the death of Carlos Dominguez would not have occurred but for the conduct of Samuel Allen Bock. If you believe that another cause, to wit, the conduct of Carlos Dominguez by failing to yield the right-of-way, was a concurrent cause sufficient to cause the death of Carlos Dominguez, and the conduct of the defendant Samuel Allen Bock was clearly insufficient, or if you have a reasonable doubt thereof, you will acquit the defendant Samuel Allen Bock and say by your verdict not guilty. 5. Now, if you find from the evidence beyond a reasonable doubt speed that was not reasonable and prudent under the circumstances then existing, and or by failing to apply the brakes in a timely and reasonable manner, which acts or omissions caused Samuel Allen Bock's vehicle to collide with the vehicle occupied by Carlos Dominguez, then you will find the defendant Samuel L. Bock guilty of the offense of manslaughter as charged in the indictment, and do not consider paragraphs 6 and 7. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of manslaughter as charged in the indictment, say by your verdict not guilty of manslaughter, and next consider whether the defendant is guilty of the lesser included offense of criminally negligent homicide. 6. Our law provides that a person commits the offense of criminally negligent homicide if he causes the death of an individual by criminal negligence. A person acts with criminal negligence or is criminally negligent with respect to the result of his conduct when he ought to be aware of a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances and viewed from the standpoint of the person so acting. 7. Now, if you find from the evidence beyond a reasonable doubt that on or about the 25th day of January 2022 in Bexar County, Texas, the defendant, Samuel Allen Bock, did with criminal negligence cause the death of an individual, namely Carlos Dominguez, by driving or operating a motor vehicle at a speed that was not reasonable and prudent under the circumstances then existing, and or by failing to apply the brakes in a timely and reasonable manner, which acts or omissions caused Samuel Allen Bock's vehicle to collide with the vehicle occupied by Carlos Dominguez, then you will find the defendant, Samuel Allen Bock, guilty of the lesser included offense of criminally negligent homicide. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Samuel Allen Bock, not guilty of the lesser included offense of criminally negligent homicide. 8. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness or investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, A juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of the fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. All right, ladies and gentlemen, each side will have 20 minutes to present their closing arguments to you. State, are you ready to proceed?
Your Honor, permission to approach the court
Yes.
briefly.
All right, ladies and gentlemen, both parties will have 20 minutes to address you in closing arguments. State, are you ready to proceed?
Yes, Your Honor.
I'm so sorry. One quick thing from both sides.
Oh, sorry. She's motionless.
All right, parties, you may proceed.
Thank you, Judge. Hi, ladies and gentlemen. I'll be speaking to you first. Then defense counsel will have an opportunity to speak with you about what they believe are important points of this case. And then the summation of this will be done by Megan Galloway, my co-counsel. I briefly want to go over some things. One, in the charge. Portions of the charge that I'd like to point out, because inevitably, a lot of times, the jury goes back to the back to start deliberating, and they send out a question. That question is, can we have the reports that were given to the officers on the stand or a witness on the stand? If those are not in evidence that are sent back to you, those were not entered, so they're not available to you. So you have to rely on the witness statements or the individuals that were on the stand, and that would be the evidence. So just keep that in mind. This is a long charge. It has a lot of information in there. You can read it and understand it and go over it a little bit more when you're back there, because I know that each time you take an oath to sit on the jury, it's important, because we're not dealing with just the individual that was charged that day. We're also dealing with the people that lost an individual that day. So keep that in mind. There's not just one person that's involved in this trial. It's several people. Now, I'm going to go over the elements here briefly with you. This is on manslaughter. Everything that you see in front of you on these screens has been proven of. The date, the area, which is Bear County, that Samuel Allen Bock, the individual sitting at this table right over here, is the individual that drove that vehicle that day at 104 miles an hour, failing to brake and hitting Carlos Dominguez, causing his death. I'll tell you this, that all the evidence that came in during this portion of the trial, or these last week and a half, one thing probably stands out above everything. And that video is what stands out in everybody's mind. Because when you first watch that video, it's shocking. It's a sudden impact that caused the death of Carlos Dominguez. It's sudden and it's fast because it was at 104 miles an hour. 104 miles an hour. You're going to hear me say that over and over. Because that was a known risk on a highway as dangerous as 181, an individual going 104 miles an hour. This is that definition of reckless, that he was aware and he consciously disregarded a substantial and unjustifiable risk, a gross deviation from what an ordinary person would do. 181, a highway that you've seen in the pictures, you see aerial photos, you heard it, their own experts say how dangerous it is for the crossovers. Over and over, 104 miles an hour. Explain 104. How can we explain 104? We have speed limits, right? Why do we have speed limits? Because it's risky when you get out on the roads. That's a known risk. That's why we have speed limits. It's a known risk. Mr. Bock knew that risk. Use your common sense and reasonableness when you're evaluating all this. Think about that. Even their own expert, 104 miles an hour. It's a known risk because we have speed limits. That's where we're going back to. Again, 104 miles an hour. Mr. Dominguez, when he was pulling out of that driveway of that restaurant, looked down that road. Even their own experts said he could see that. The 18-wheeler was in front of him. Down the road, he could see down that road, down that grade. Now, did he see that silver Cadillac? silver Cadillac with that silver background going 104 miles an hour? Maybe. Thought he could make it. Even their own expert said that a person would not expect somebody to be going 104 miles an hour. This highway, driver expectations on this highway. Even the defendant's own words that he saw the black SUV on the shoulder. Now there's a discrepancy between the defendant's statements and their expert and the video. Because for the 5 seconds preceding, the SUV is moving the whole time. Mr. Bock said it was standing still. Expert even says it was moving. So if you see a moving vehicle on the side of the road coming onto the highway, because you can see from the video, watch it yourself. Mr. Dominguez is driving towards the highway. This individual should have seen that and expected that vehicle to try to make it across. Or at least you let off that accelerator, stop going 104 miles an hour. That was a risk that he was willing to take that day. A known risk on this highway that everyone knows about. There's also a lesser included portion of this case that the court has entered into your jury charge. It's a lesser included offense. So if you decide that Mr. Bock was not reckless that day, and you decide that he's not guilty of manslaughter, recklessly causing the death of Carlos Dominguez, then you move to criminally negligent homicide. And I highlighted some things here. Ought to be aware. Go back to that 104. 39 miles an hour over the legal speed limit. Mr. Bock was breaking law, like probably many of us do. Maybe in this morning, coming here in the morning, you might have gone 70 instead of 65. You might have gone 75 instead of 70. Well, there might have been people out there on the road that you saw this morning going 39 miles an hour over the speed limit. The reason we have speed limits is that people are aware of the risk, a known risk. And that's one of the things that he was aware of when you get on that road. You ought to be aware of it. You are aware of it. That is the difference. That's why it's not criminally negligent homicide. It's manslaughter. That known risk. The defendant's own words. I was going the speed limit. That's why he said that. I think you would know the difference between 104 miles an hour and 65 miles an hour. 39 miles an hour over the legal speed limit. That's why he said that. This is the guilt innocence phase. This is about guilty or not guilty. It's not the punishment phase. This portion is just to hold Mr. Bock accountable for what he did that day.
8 minutes.
Thank you, Judge. Hold him responsible for what he did that day. It's not the punishment phase. That's a different portion. That's a second portion where it's determined whether prison time or probation or combination there. This is to hold somebody responsible for causing the death of Mr. Dominguez, recklessly causing the death. It was a manslaughter. Mr. Dominguez was 87 years old. And if you ask me, a healthy 87-year-old maybe has some heart problems, maybe has some kidneys problems, but he's 87 years old, made it through his whole life to die on that road and to be blamed for it all. 87 years old, played 18 holes of golf, does that weekly, if not more than once, twice, or sometimes 3 times. He was a veteran, 87 years old. And Mr. Bock recklessly caused his death. Hold him responsible for what he did that day. Thank you.
Your Honor,
Right, defense.
if I can have this moment set up
Yes.
and, do you mind switching the PowerPoint?
I'll do it.
We just did it beforehand. Hold on just a second.
I know. Hold on.
This one?
No, this. the HD one.
Oh, I need.
Yeah, I would have to do this one.
Okay.
So, and then if you want to set it right there.
Yeah.
Okay, yeah, it's fine. Let me finish this. Oh, thank you.
All right. Thank you for your patience. All right, so as you're aware, the state, has brought the charges against Samuel. In the jury charge, well, actually, what I want to talk to you about is that you're noted in the jury charge that they're asking for a conviction on manslaughter. And then the jury charge includes a lesser included on criminally negligent homicide because, and I'm going to explain to you the difference. When we were in Vordaer, we talked about the fact that this is not a murder case because in order for it to be a murder case, the mental state has to be intentionally or knowingly. In this case, manslaughter requires recklessly for your mental state, and criminal negligent homicide requires criminal negligence. So let's talk about the actual difference though when we look at the elements, and there's not much difference when you look at the elements. Manslaughter elements, the state is required to prove each of these elements beyond a reasonable doubt. The first is the most obvious line in here, and it said Samuel Bock recklessly caused the death of Carlos Dominguez. That's one line, and it has recklessly and cause. In the next paragraph, it's going to say by driving or operating a motor vehicle at a speed that was not reasonable and prudent under the circumstances then existing, and or by failing to apply the brakes in a timely manner. And then finally, which acts or omissions caused Samuel's vehicle to collide with the vehicle occupied by Carlos Dominguez. Now, when you get to, if you do get to criminally negligent homicide, you will see that the only difference is by the criminal negligence part. It's the mens rea. That's the only difference here. The analysis on each one is the same. With that exception. Is driving 100 miles an hour reckless or criminally negligent? Maybe. If we were outside this courtroom, maybe you'd say yes. But you're not outside this courtroom. And in this jury charge, the court tells you the risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances and viewed from the standpoint of the person so acting. Now, what does that mean? We heard evidence from from Officer Garcia that people routinely and regularly travel 90 to 100 miles on that road. That road is open, it's bordered by ranches on either side, and it is straight. The traffic lanes at the time or the location are straight lanes. And in this particular instance, there is a big gap in time between the 18-wheeler and the next car that's behind Samuel Bock. So under those circumstances, there was no one in his vicinity at that particular time. So when you look at whether or not someone is criminally negligent or reckless when they're driving 100 miles an hour, we can't just automatically assume that we think it is. We have to say, by the law, under all circumstances. And according to Officer Garcia, ordinary people do drive 90 and 100 miles on that road regularly. Causation. Okay, I pointed out that there's two causes in that when we look at the elements of manslaughter, you see how it says recklessly caused the death, but it also says which acts or omissions caused the vehicles to collide. Okay, so we've got two different causations. All right, so even if you find that driving 100 miles per hour is reckless or criminally negligent, the state is still required to prove beyond a reasonable doubt each of the causations. The first one is that it caused the vehicles to collide. Well, we had an expert that told you, that did the calculations and showed you that at 144 feet out, which is when the hazard became apparent, that it would not have prevented an accident even if someone were going the speed limit. So, but for Carlos Dominguez failing to yield right of way, we wouldn't have had an accident. It was his sole act of failing to yield right of way in the pause that caused the accident and caused the collision. The next thing we'll talk about is the collision. Did it cause the death of Carlos Dominguez? In regards to causation, we have concurrent causation, and it reads, you cannot find the defendant in the jury charge, it's a quote, Samuel Allen Bock guilty unless you believe beyond a reasonable doubt that the death of Carlos Dominguez would not have occurred but for the conduct of Samuel Allen Bock. And that's just absolutely not true. I understand that the state has focused so much on 100 miles per hour, but that is blinders because the totality of the circumstances have to be considered, and you cannot ignore Carlos Dominguez's actions or inactions just because he's not here. You have to look at that would not be fair to anybody. That is not justice. You have to look at his actions and size them up with the facts that we are able to bring to you, and then consider whether or not if he had just even waited a half a second, if he'd still be here because he just failed to yield way. Did Samuel's speed cause the collision? Our expert told you it did not. And he went through the scenarios to explain. It would not have avoided the collision because Dominguez had not, yielded at that point, and he didn't stop at the shoulder. Let's talk about the witnesses. In voir dire, I asked people, hey, how accurate are eyewitnesses? And this is a great example. We had 3 eyewitnesses that the state tried to call, and Kurt Fuller, he heard it, he didn't see it. We heard from Melissa Cox. She didn't see the accident. She said she was going 70. And then at the railroad bridge, Frank Garcia says he's going 65 on cruise control at the railroad bridge. And yet he's the first one to make it to the scene. And when you see his truck, wait and see how long it takes for Melissa Cox to get there. Now, is this a big point? No, it's not. But I'm just pointing out that none of their witnesses actually saw the accident. What you saw in that video is a blessing because we actually got to see what Carlos Dominguez's driving behavior was at that particular time. And in my opinion, it is unreasonable not to have stepped on your brakes or to taken a second look or a third look to make sure you're clear to go. All right, the analysis. Officer Shannon talked about the 5 seconds out analysis. Here's the problem with the 5 seconds. Well, even under that analysis, he said, yes, the accident would have happened at 104 miles an hour, but it may not have happened at 70. So he doesn't know. He was unclear, but he said the accident would not have happened at 65. Now, we heard from Dr. Eftekar, and he told you that the reason he ran his analysis at 2.5 seconds is because that is the time at which the vehicle enters a position to become a known hazard. And he could tell that through comparing the times on the crash data report to the video. And from Dr. Eftekar, he said the accident would have absolutely happened whether you were driving a speed limit or driving 104 miles an hour. Okay, we cannot, in my opinion, and I think Dr. Eftekar testified to this, you cannot just randomly pick a 5-second start mark to do your analysis, because I even asked, if you'll remember, Officer Shannon, I said, hey, so if this went back 7 seconds, is that what you would have based it off? And he was like, yeah. I'm like, that's so random that if you had just left or taken 1 more minute eating, those kind of random events, you have to be able to eliminate and look at just the fact pattern that is directly related to the accident. So the starting point begins from when the hazard presents itself. And that was at 144 feet. Now, this is 2 seconds to impact. As you can see that Dominguez has not entered the roadway. He's still on the shoulder. He's now at 1 second in the middle of the first lane. And then at 0, we have the contact. Now, I want you to go back and look at the pictures. Bock never lost control of his car. That's interesting to me because the state says how reckless he is in driving 104. But when he slams on his brake, he maintains the single lane. You can see from his brakes that he doesn't, swerve or cause any additional concerns in regards to what lane of travel he's in. Okay, impairment. This picture is in the pictures there. You can see that Mr. Dominguez's zipper is unzipped. That's a sign of impairment potentially. But what are the other signs of impairment that we need to consider? And that is that he failed to yield right of way. That's another sign that he wasn't thinking correctly. But then we also brought you what the state did not go and do is the medical records. And the medical record the day before lists all the things he says he's taken. And I know that it sounds like, hey, he is like, out there doing golf, 18 holes of golf. I'm exhausted after 9 and I'm ready to be done. He did 18 and he shot a good score. This guy was hurting. When you look at the medical records, he had chronic pain. That's what that muscle relaxer was for. There is no ability for the state to rule that out, that he might, after having played 4 to 6 hours of golf, needed a muscle relaxer because he's in pain now. So we cannot eliminate facts just because the state chose not to go look at them. We need to take into account all of the facts. And in addition to that, Tanzanidine, the problem with it is that the state had the ability to bring you experts who could have said, hey, we tested and ruled it out, but they didn't. What they did is they didn't call the 2 people who could have told you, hey, it was tested for and we ruled it out. Why not bring you that? All right, and the prescriptions in the car. Oh my gosh. If you collect prescription medication from a car, you need to note it. The fact that we have an officer who thought it's not important to write it down or to like at least give that information to the medical examiner so that they can determine and do a full investigation is concerning to me. Okay, the lack of evidence for impairment is also on the state. Now, I want you to remember this. The state has a burden of proof on each and every element. They don't get a pass just because they didn't go collect the evidence. But let's talk about the missing cameras. If there's other cameras, they didn't know. Did you go ask for the additional footage because someone else clicked it? You can tell that it has the capability of recording for a very long time when you watch that footage. But they clip it to start at that exact time when the car's already in motion. That is concerning to me because, well, would we have been able to see Dominguez walking in the parking lot? We don't know, but the state didn't take the time to go look. And they have the burden to do it. As you remember, the judge told you that the defense has no burden of proof or production. I'm pointing this out because it is important given the fact that when we go get the medical records, we start to have more questions than answers. All right, did Samuel's failure to brake cause the collision? No. And Dr. Eftekar was very clear about that. He said, look, when we look at the, first off, the Texas Driver Safety Handbook, the average response time from the time you observe a hazardous condition to the time you respond is on average 1.5 seconds. And in this regard, we can see that at when you see the car on the shoulder at 2 seconds, and you look at the reaction of stepping on the brake, it's almost simultaneous when you compare those two. All right, did the collision cause Carlos's death? Maybe, and we're never gonna know that answer, and that is on the state. And that is because there's a lot of things that they didn't go look at. But we know that he had kidney disease, stage 4, and that he had declined treatment. We also showed you, because the state, I thought it was interesting that initially they were like, oh, just significant blockage. It wasn't significant. It was 90%. You go play golf for 6 hours and you don't think that that's causing overexertion of your body? For someone that's 87 years old, who knows if his widowmaker artery just completely gave out. And you heard from their Dr. Tran that yes, that could have happened. And she can't rule it out because they didn't go look for it. They also can't rule out the kidney failure that could have caused him to become to collapse. They can't rule that out, or the arrhythmia because they didn't run those metabolic tests that would give us more information to say, hey, based on the fact that he didn't yield right away at all, no braking, no blinking, no blinker, bad angle, risky maneuver at 144 feet, you can tell if a car's going 104 miles an hour at 2 seconds. Just step on the brake. You would be alive. Why did you not step on the brake? That's the question. So we have to look at other issues because I'm like, hey, if he didn't step on the brake, is there something else causing this? Suicide. There is some reference that he was depressed in the medical records at times. But that's not really the biggest thing. What I wanted to point out on this was that even strong-willed people have their breaking point. He knows death is imminent because of his medical condition. He's refused treatment, so he's chosen to not live or to try to live. And when you look at some of this other, you're going to see on here and ask about social history and community ties. And he's asked community involvement. No. All he does, from what we can tell at this point, is that he plays golf once a week and then he goes home alone. Nobody, we don't know how often he sees his girlfriend, if he sees her at all anymore. You know, I mean, my point is he's very isolated and he knows that the end is coming. So I don't know if he was distraught, distracted, upset. We don't know that, because on that no-go zone, I can't imagine that someone in their right mind would have ever chosen to go under those circumstances. All right. Okay, what did the state not bring you? The accident report. Why not? I mean, that's a standard document. Why do they not want you to see it? What about the summary of his current med? What's the secret there? I mean, toxicology report, the raw data. Why? I tried to give it to you. I gave you every document I could, because I'm not trying to hide anything. I think that you can only make a good decision if you have all the information. And the list of drugs tested was in that toxicology report to some extent, but you would have had to need another expert to fill it in the gaps. And then any evidence of suicidal ideations. All right, expert witnesses. Now, expert witnesses are paid. Dr. Tran came in here, she was paid. The two other expert witnesses that we had were paid. That is common. That is not uncommon for us, the state or the defense, to have to pay for their time. We can't expect someone who really knows what they're doing
2 minutes.
to not come in, or to come in just on their goodwill. What does not guilty mean? It doesn't mean that you approve with someone driving 100 miles per hour. That's not what it means. What it means is that the state hasn't proved each and every element of the offense that they've alleged. At the end of this, I believe that you will return a verdict of not guilty on both manslaughter and on criminal negligent homicide, because they're basically the same thing with the exception of the level of intent, the mens rea. Okay, I started this all out with saying, hey, when the only thing you look for is a rabbit or a duck, you're missing the fact that it's just ink on a paper. They're only looking for 104 miles an hour. Your job is to be active listeners and critical thinkers, and it is to consider all of the evidence. And if there's a scenario in this instance where we have 3 different speeds that accident would have happened even at driving the speed limit, there is no way you can reach beyond a reasonable doubt to find Samuel guilty of either manslaughter or criminally negligent homicide. Thank you.
All right, states you have 10 minutes, 55 seconds.
I'm in the back of a fucking cop car. I don't see why they had to put me back here. Ladies and gentlemen, that defendant knew then, he knows now, and now you all know why he was behind in the back of that patrol car on that day. And we're going to talk about the law that supports that. Now, Mr. Garahan went over the elements of manslaughter with you, and I'm going to talk about some of the definitions and the evidence that supports the reckless mental state. As we stated in jury selection, you're not required to be a mind reader, okay? You are allowed to infer the mental state from words, actions, and circumstances. So let's look at that. Regarding the defendant being aware of but consciously disregarding a risk, we're going to look at the defendant's own words, okay? When he's sitting in the back of that patrol car, what is he saying? The person I hit was on the shoulder. They weren't in candelas, they were sitting on the shoulder. He was sitting still, then pulled in front of me, okay? He was aware that that black SUV was on the shoulder, and he decided to proceed on 181 at 104 miles per hour. That is reckless, and I am going to harp on it because it goes to his mental state. Gross deviation from the standard of care that an ordinary person would exercise. In this case, we have 2 ordinary people. and you are putting yourself in the standpoint of the defendant, you are not using the reckless mind of him, okay? We're using the mind of an ordinary person. And who is that in this case?
Your Honor, objection, that's a misstatement because it says standing in the standpoint of the accused.
All right, ladies and gentlemen, the law is the law that is in the charge. Does everyone understand? All right, you may continue.
So who are ordinary people in this case? Melissa Cox and Frank Garcia. Let's look at their testimony. They were on US Highway 181. They saw that silver Cadillac approaching the rear. Melissa said that the truck was approaching the rear of her truck at a high rate of speed. She looked down at her speedometer and she was going 70 miles per hour. And the defendant passed her up to the point where she lost sight of him. She believed that the defendant was going to hit her. That goes to recklessness. And she said to herself, holy crap, this person is flying. That lets you know how fast he was going. Frank Garcia, on the same highway, he had his cruise control set to 65 miles per hour. He said that the silver Cadillac approached the rear of his truck at a high rate of speed, which caused him to switch lanes. The defendant packed him up also, and he said the defendant was hauling butt and made him feel like he was standing still. This is a manslaughter. The defendant is guilty of manslaughter, not criminally negligent homicide, because he was aware. He wasn't ought to be, he was aware, and he told you that from his own mouth. This is just like the hypothetical I gave in jury selection, where Bree saw the risk. She knew that Juanita was behind her car, and she proceeded to back up anyway. Let's talk about the testimony. Kurt Fuller testified he was at Abdanabi's. He observed the crash as it occurred in State's Exhibit number 2, which you all have seen. He observed smoke and the loud squealing of tires and observed Carlos Dominguez take his last breath. Deputy Garcia made the scene, did traffic control, and took witness statements. Now let's talk about Sergeant Shannon. Okay, he maps the scene, he documents the road evidence, he extracts the airbag control module, and he analyzes that data. And his 5 seconds are correct because the defendant saw Mr. Dominguez in the shoulder, okay? And so we're gonna do the 5 seconds. He saw him. That is when the hazard presented itself. And he should have taken action then to slow down, to apply the brakes. And he didn't. He proceeds to go at 104 miles per hour. That is unreasonable. No reasonable person would do that. If we look at the speed from the airbag control module, which was 104 miles per hour, when Mr. Dominguez was sitting there in that shoulder, the defendant was 688 feet away. Okay. Had he been going 70 miles per hour, like Melissa Cox, he would be 513 feet away. Had he had been going 65 miles per hour, 476 feet away in 5 seconds, 5 seconds before. And the delta V, this is important, okay? Sergeant Shannon testified that the fatal delta V in any crash in his training experience is a negative 23 to negative 24. In this case, it was a negative 37. Mr. Dominguez never had a chance with this defendant on the road that day. Speed limits exist for a reason, and Sergeant Shannon testified to this. He did take the fact that Mr. Dominguez did have the duty to yield under consideration in his analysis. But the defendant was not operating his motor vehicle in a lawful manner. And that's important because that's what the right-of-way is. He was not, you cannot, say, well, I have the right-of-way, so I can just do whatever I want. I have the right-of-way, so I don't have to follow the law. I can slam into somebody and kill them. The law does not entitle a defendant to that, okay? Investigator Callender testified that speed was a major factor, okay? And his analysis of the case and the evidence that he collected and the witness statements that he took. And he detains the defendant and speaks with the defendant. And what does the defendant say? I was just cruising down the left lane. He cut me off. There was no avoiding it, okay? he's intentionally concealing. He's not saying the speed that he was going. He tells his grandparents he was going the speed limit. And why is that? Because he knows that there are repercussions for his actions that day. And that was his story to law enforcement on the scene, and he was sticking to it, okay? Until the evidence comes, the witness statements, the airbag control module, which their own witness testified, okay, cannot be manipulated. So he was going 104. And then the Candela's video that he didn't know about. So then after viewing all of this, they concoct this story where he has no criminal responsibility. Oh, the victim took Benadryl, but we don't know when. Oh, he didn't look, which nobody can know because he's deceased. Oh, the victim had kidney disease, and the victim could have been on the phone. I want you all to look in the autopsy report. That victim's phone was clipped to his wallet, and it was bent and shattered due to the actions of that defendant. Okay, so the only phone records that we would need are his. Let's talk about causation, the criminal responsibility. The defendant is criminally responsible in this case. The crash would not have occurred but for his conduct, either alone or concurrently. That concurrent cause could be the failure to yield the right of way. However, the crash would not have happened but for him traveling at a speed of 104 miles per hour. So what does this mean? If it's the defendant plus something else, the defendant plus the failure to yield the right of way, he is guilty. You would have to find that Mr. Dominguez, just being in that intersection, was alone to cause his death, to find him not guilty. And there is no evidence to support that. Now, you are the judges of the credibility of all of the witnesses that testified. And so you need to consider, what do they stand to gain from their testimony? Let's talk about Mr. Jellick, okay? He cannot tell you if Mr. Dominguez was impaired at the time of his death. Point blank, period. Okay, he testified to it multiple times. And so what does he stand to gain from coming
2
up in this
minutes.
court of law? Okay, would he have been retained if he had the same opinion as a state's expert? Would Mr. Aktifar have been retained if he did the math in the same exact manner? I submit to you, no. Now let's talk about Mr. Aktifar, okay? Dr. Aktifar. He estimated the defendant's perception, and it was incorrect because it was based on when the defendant decided to brake. But we know from the defendant's statement, he had seen the victim's vehicle prior to that, okay? He even testified that the defendant had a duty to slow down, and he cannot rule speed out as a factor. Ladies and gentlemen, had the defendant been traveling at the speed limit, he would have arrived to the point of impact at the same time as Melissa Cox and Frank
Objection,
Garcia.
Your Honor, that's facts, not an evidence.
It's a reasonable deduction from the evidence.
All right, ladies and gentlemen, you remember the evidence as you've received it?
Go look at State's Exhibit number 2 and see when they arrive at that intersection, okay? The victim would have been able to clear that crossover 3 times over. At fault, and I think Mr. Aktifar may be getting confused as to the standards, okay, because he testifies in civil a lot. At fault is not the standard here. It's criminal responsibility, and the defendant's acts plus something else means guilty. Guilty on manslaughter. Dr. Aktifar can't testify to the fatal injuries. Go look at the autopsy. Heart severed, ribs shattered, pelvic bone shattered. And Dr. Trang testified that all of these are consistent with high rate speed crashes. Now, Jason Winnell already went over this with you all, but your verdict matters, okay? Protect the community. Send a message to the community that this type of behavior is not okay. If you are driving recklessly and causing the death of somebody in our community, you are going to be held responsible for it.
Time.
He's lied to his grandparents, he lied to law enforcement, and he'll lie to you. Find him guilty.
All right, ladies and gentlemen,
Yeah.
I was
Hey, what's going on?
Yeah.
Good morning.
Working, huh?
Let me know when you have a second. Okay, ready to come in early, gonna get in and get out. Feliciano Mora. Should be
Yes.
2 drug cases, 1 for pot, 1 for powder.
Yes.
But the labs, I didn't see the labs for one and I didn't see the file for the other. I know, we brought a few more down. His history's from like the 80s.
Oh,
Yeah, too.
ways here to meet with
Oh.
mine. Yes. So. All right, yes. All right, thank you.
What's happening here?
All right, attorneys, the
Which one is
same
this?
rules apply. So,
They said
um,
he didn't see a lab
please
report on the
confirm.
marijuana.
And if you're
Or
ready,
say
you
no
need
about
to
it.
approach the court coordinator and have them pull your files, and I will call you up in the order of appearance.
Docket.
All right, Norma. And some of this is now, it is the chat. Okay, he's here.
All right, thank you.
I'll tell you, how long have you coming?
Hey, let's start with the. Sorry.
Joking. I'm also having like the shittiest day ever, so I don't want to fight. Like I should cry at any second.
I don't need these people thinking I'm mad at someone or whatever. We're good.
The joke.
Good, I love you, don't worry.
We can't joke anymore. That's like my whole personality. So
No.
sorry, Toasty. I will take you out.
Someone's gonna be self. I love everyone. Well, okay. There's we don't have to do that, I don't like. There's one that's good. Oh, see,
Yes. Oh, thank you. Try to keep good notes.
They're very good. And then she relabeled that yesterday, right? So there's nothing to do on the
No,
record.
those were just relabeled as the
Okay,
alphabet.
very good. Thank you.
I guess we can start these deputy.
And to the court reporter, don't lift those heavy things you're expecting. The deputy can take
Okay.
those back.
Sure.
All right, everyone, thank you for your patience. We're going to proceed in an orderly manner again. I'm going to go in order in which I receive files. Diego Chavez.
Present, Your Honor. All the way down, second seat, all the way down, second seat.
All right, so do you want a jury trial, sir, bench trial? Have you all reached an agreement?
Jury trial, Your Honor.
All right, how long you are expecting this trial to last?
2 days.
All right, and is it criminal trial division or family violence?
Criminal trial division, Your Honor.
All right, Ms. Ferguson, I need a jury trial date for criminal trial division, 2 days.
You need this 1 second.
Lama, where you at?
Where's Rex though?
If you want to set it September 8th, Judge Angelini will be here because I'll be serving jury duty.
Bean, where you at?
All right, September 8th.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, thank you. And thank you for dressing appropriately for court, and I appreciate your patience.
Oh, yeah,
Umberto Lira,
You just saw him. That would be September 8th, you said it's.
yes. No, that's for Chavez.
Oh, Chavez?
Yes. That's what I said. Diego Chavez. All right, so I know your client had to leave.
Yes, Judge, he's on his way, or he's probably back at the hospital now.
All right,
So I just didn't know if you needed to give us a date or how you.
so we're gonna put you for jury trial for September 8th. All right, once you, well, your client will know, correct?
Yes, Judge.
All right, thank you so much.
Can we tell the judge that? Thank you. Judge, may I approach?
Just one moment.
Yes, ma'am. Oh, I'm sorry. I'm writing on the Wade matter. Wade. And he's on Zoom. Okay. Thanks.
Jared Michael Wade.
He's on Zoom, Your Honor.
All right.
Starts.
Yes.
I'm sorry, what's your name? Lauren, I'm sorry. Yes, ma'am. Okay. All right.
Jared Michael Wade.
Yes, ma'am.
Excuse me, Mr. Wade, you're on Zoom with the court.
Yes, ma'am.
Thank you, Mr. Wade, for waiting.
How you doing? Yes, sir.
All right. Michael Wade,
Yes, ma'am.
Mr. Wade.
Yes, ma'am.
Zoom with the court.
Yes, ma'am. Yes, ma'am.
His,
That's you?
you need to turn off your computer. All right. So what is the purpose of this hearing today?
Your Honor, you granted him deferred adjudication and you reset it today for a restitution hearing. To find out if there was any damages to the police officer and how much.
All right. Is there a restitution amount?
Your Honor, looking at our notes here, I don't see the complete amount or less. communication with, this officer was on 523, and the sergeant was saying that he would get that amount. And I don't see it, so.
All right, so we've been waiting on, let's go on the record. The court is calling 2025 CR 004949 and 2025 CR 004950 State versus Jared Michael Wade. Could I have parties announce?
Lauren Espinoza for the state, Texas.
James Seeloff for the defense.
All right, and Mr. Wade is by Zoom. Any objection to the defendant appearing by Zoom?
No, Your
No, Your Honor.
All right, so we're here for restitution hearing off the record. The state has informed the court that they do not have a restitution amount. This case has been on the docket for restitution since June 26, 2025. It is now August 12th, 2025. The court is going to find that there is no restitution due.
Thank you, Your Honor.
Thank you, ma'am.
All right, is there anything else?
No, Mr. Wade, do everything the probation office tells you to do.
Yes, sir. I will. Yes, sir.
We'll be fine.
All righty. Thank you very much.
Thank
All right,
you.
you're
Thank
excused.
you, Lauren.
Thank you, Judge.
Thank you very much,
You're welcome.
Your Honor.
All right, bye-bye.
Goodbye.
But Sean, there's to be no restitution in that case involving Mr. Wade? Yes.
Thank you.
And Norma and Norma? Okay.
With your tortilla.
Hey, where are you? All right.
Well,
Yes.
All right, Andrew Thomas Reyes. Is he on bond? Deputy Laura? Andrew Thomas Reyes. Is he in custody or not? He never showed, correct? He's on page 5.
No, Judge, I did not.
Andrew Thomas Reyes. Who's here? Joshua Hernandez Medina?
I am Judge.
Are you all ready to proceed on the motion?
Yes, sir.
All right, can I have a file stamp for a motion to revoke, please?
Yeah.
All right, and this family violence or criminal trial division?
Family violence.
All right, so Rick,
Morning, Young.
good morning. How are you doing?
Just glad to be here today.
Okay,
Thank you for seeing me.
all right, you're welcome. Court is calling 2019 CR 9100 State versus, just one second. If y'all can just either ask the deputy to move him down to that end. Okay. Court is calling 2019 CR 9100 State versus Joshua D. Hernandez. Could I have parties announced?
Griffin from the state of Texas. Scott Hill for Mr. Hernandez.
And are you Joshua Hernandez?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Joshua D. Hernandez who was placed on deferred adjudication in 2019 CR 9100 for the offense of injury to a child with bodily injury on November 13, 2019 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Which we're here this morning on state's motion to introduce adjudication of guilt and revoke community supervision. Violation of condition number 2. On or about the 22nd day of April 2025 in Bear County, Texas, the defendant Joshua D. Hernandez did fail to submit drug testing as directed by the court officer, supervision officer, and a duly authorized agent of the court, and violation condition number 2.
How do you plead to that? True or not true?
True.
State will waive the remaining violations, Your Honor.
Any objections to the waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Sure.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There's not, Your Honor. Both statements with both of the court for our recommendations.
All right, so state you're requesting revocation.
Revocation, adjudication of guilt, and then a prison sentence at the court will appropriate.
All right, and defense, what are you requesting?
Judge, we are requesting that you follow probation's recommendation of him to be applying for a drug court. And I've got a witness, his younger sister, if you'd like to hear from her.
Yes.
Julie, Lorianne DeLomba.
There, on this side, put your back against the corner.
Hello. Hi, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Loriana DeLumba.
All right, you may proceed.
Ma'am, how are you related to the defendant, Mr. Hernandez?
He's my older brother. I'm his-
And are you two close?
Yes,
Are you his younger sister or older sister?
younger.
Where does your brother live right now?
He was like with my grandma.
At your grandma's?
At my grandmother's. Yes.
Jesus.
Oh, I'm sorry.
That's okay.
And who else lives with your brother and your grandma?
My mother and our aunt.
And does your mother and grandmother rely on your brother for care?
Very much.
What does he do for them?
My grandmother just had a stroke at the end of last year, so he takes care of her most of the time. Also, my mom, she's has mobility issues, so he helps around the household.
Do they depend on him
Yes,
a lot
a
for
lot.
their care?
He's the only guy that lives there, so he helps out a lot with him.
And does your brother have any children?
Yes,
And how old are they?
10 and 9.
And does he spend a lot of time with his children?
Yes, he sees them every weekend.
Do you think he's a good father?
Very much, yes.
Would does he get along with the kid's mother?
Yes, they have a healthy relationship, co-parenting.
And the court has a couple of options today. So should the court sentence him to jail, prison, how would that affect his kids?
The mother of his children work, so he watches them quite a lot for, I don't think it was benefit. In my opinion.
And how would that affect your grandmother or mother who rely on them? Would anybody else be able to step up to the plate and take care of them?
Sorry.
What, this is your brother's third MTR. Why? What makes you think that he's going to respond better this time?
The last, when I talked to him before he came, he seemed very serious and he knows this will affect us. I'm sorry. He plays a big role in our families. So. And we hard if he wasn't there because he helps a lot.
Thank you for your time. You may have some questions.
Loriana Yolanda?
And you're the defendant's sister?
Yes.
Have you ever known of your brother to have a problem with drug use?
I have
And to your knowledge, what drug does he abuse?
marijuana.
How long have you known of him using marijuana?
To my knowledge, for a while.
Then would that be months, years,
Years.
years, okay? You mentioned that he has children, right?
Yes.
You believe he's a good father to them?
Yes, sir.
Have you ever seen him use drugs around his children?
No, sir.
Have you ever seen him to be in possession of drugs if he's around his children?
No, sir.
So to your knowledge, he smokes marijuana whenever he doesn't have his children around, is that correct?
That's what I'm aware of. Yes.
Have you personally seen him smoke marijuana?
No,
Okay. Have you ever seen him to where you feel him under the influence of marijuana? Has he told you so about? his
Yes, sir.
marijuana use? To your knowledge, has he tried to get help for that?
to my knowledge, I know that he goes to the drug classes for this.
Have you seen an improvement in getting things marijuana use with going to those classes?
Yes, sir.
I'm gonna put a question, John.
Just to follow up, Judge.
Sure.
Did you and your brother recently lose a sibling?
Yes, sir.
And was that your other brother?
Yes.
And how did Joshua handle that?
We take it very hard. They live together, so.
Nothing further, Judge.
All right, thank you so much for giving me insight.
Judge,
Oh, you want to come forward? So,
I represented this young man on the second MTR, and I remember him clearly. I think it's taken him this much of a wake-up call to understand how this is affecting his children. That's what he's most concerned with. He is so motivated right now, Judge, to do whatever you ask him to do. He can't fathom the thought of being locked up and his kids being without their father. And that would be a tragedy due to the fact that he's on deferred right now. I mean, he has a clean record up to this point, as far as convictions go. So he's got a job with his uncle. He's got a job waiting for him. But he does want help, Judge. He's been to treatment before, for whatever reason that didn't hold. But I think the drug court will be a little more have a little more influence on him, be a little more structured for him.
all right, so let me explain to you what my problem is. My problem is, this is not about the use of marijuana or not the use of marijuana. That violation is his not even showing up for a drug test. And this is his third motion to revoke. And the underlying facts of this case, you know, the facts of the case, and part of my conditions, he's not even supposed to be around children unless he's supervised. So, yeah, according to your supervision that I placed upon you, because of the nature of this case, there was to be no unsupervised visitation. Like you could be around your children, but there had to be an adult there.
Well, Judge, he lives with his grandma and mother, and then kids come stay with him at the house, so there is supervision.
All right. And then he's been placed in, I think ISF before. Then you were before Judge Angelini, and Judge Angelini didn't revoke. And it was again, the same thing, a violation for number 2. And that was in April of 2024. There's nothing I can do for him. I mean, if you don't even show up, there's nothing I can do. So I'm going to grant the motion. I'm going to revoke, find you guilty. Does anyone wish to speak to punishment?
And just have
Yes.
your time.
Sure.
I get out of ISF. 5 months later, my brother takes his life. It devastates me. I watched him destroy himself. I did my best for the 6 months that I could to keep it together. I know that I am the man of the house, and I don't want to be selfish anymore.
But here's the thing. Did you pick up the phone and call probation?
Yes, ma'am. I speak to Mr. Tues. He's a great probation officer.
No, I mean, did you pick up the phone and call them and say, hey,
Yes, ma'am.
I'm not going to be reporting for my drug tests? Or did you just not report?
No, I was going. It just came out dirty. Grandma had a stroke. I came out of ISF. I had to wipe her butt. I had to beat her through a tube.
Mhm.
I got my GED. I got my driver's license. I took my permit.
Mhm.
I got a job. I'm so motivated.
Yeah, I mean, but here's the thing. You've been on probation in this court since 2019, and you've had 3 motions to revoke. At some point, there's nothing I can do. I'm all for when people are placed on probation, I'm all for helping people, but at some point, there's no more I can do.
Your Honor, the second time I went to ISF, they did ask for drug court. They said I went. And I came back, and every time I come back, you know, I'm more behind, and I know how serious.
Judge, there's one more thing. Try drug court. We haven't tried that yet. It does help a lot of.
No, I mean, I don't think there's anything else I can do for him. He doesn't show up. That's the problem. The problem is not he's testing positive for marijuana. And I know people will say with marijuana, it's just marijuana. But part of his conditions is that he's not to smoke marijuana unless he has a prescription for it. But my main thing is if you can't show up, then there's nothing we can do. And he keeps coming back for a violation of condition number 2. And violation for condition number 2 in this case is not his testing positive. It's he doesn't even show up for the test.
Your Honor, I just had appointments with my grandma, just transportation issue. I knew that I needed to get a driver's license. I paid cash for the impact. I passed the writing exam. I have my driver's test on the 8th of October, and I'm ready to go to drive to work so I can get to the places that I need to go.
I mean, Judge, there's tests. I mean, and he fails several of them.
Yeah.
So it's not like he just refuses to test.
But he keeps not showing up, and he's already been to ISF twice. There's nothing else I can do.
Judge, may I please get help? My sister's going to counseling, my mother's going to counseling. I would like to go to counseling and go to drug court and successfully finish this. I have 1 year left. I haven't got any more cases. I'm not getting in trouble.
All right, so here's the thing. When people tell me that they don't have any more cases, they didn't pick up any new cases. Here's the thing. Nobody here, your attorney hasn't picked up any new cases. No. I hear what you're saying, but I want you to, for you to understand me and internalize what I'm saying. It's similar when people have children and they say, I pay my child support. It's like, okay. So it's sort of like, many people in this courtroom don't have any cases. Many people in this courtroom, they're on probation, and you know what they tell me? I haven't picked up any new cases. Well, I hope not. But the problem is, I don't believe there's anything else that I can do for you at this point. Now, I'll retain jurisdiction, but I'm going to find violation condition number 2 true. I'm going to revoke, find you guilty, give you credit for any time served. There's to be no residing with minors, no unsupervised contact with minors. There's an affirmative finding of family violence, and there's the therapeutic community. Does anyone wish to speak to time?
Say we'll defer to the court,
What are you requesting?
the minimum time, Judge.
All right, I'll sentence you to 5 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. And counsel, I'll retain jurisdiction. All right, thank you.
Have you excused me?
Yes. Just one moment. Yes.
Can you let me in to meet with Alexander Rodriguez on Zoom? That's all. You can put
Okay,
me in a
sure.
breakout room.
All right, yes, we'll do.
Thank you, Judge.
Is the interpreter here for someone? Who is she here for?
Mr. Aguilar or Ms. Martinez.
Do I have a file on Aguilar?
You should. I don't know.
All right, sir, if you go to the breakout room, Mr. Rodriguez, and it's breakout room number 2, I've requested that you go there. Hector Renee Aguilar.
Judge, present room.
All right, and he's the one with the interpreter?
Yes, sir.
Hi. Good morning. All right, if he'll come up. All right, today is plea deadline date.
Yes.
All right, have you all reached an agreement? Are you requesting a trial?
Just, we need a jury trial.
All right, how long do y'all expect this trial to last?
2 days, Your Honor.
All right, Ms. Ferguson, I need a jury trial date, family violence, 2 days.
There's 2 charges, Judge, and we've got a case 2, so I would say at least 3 days.
I apologize.
All right, 3 days.
October 7th.
All right, Norma, are you able to put this on? What is happening on September 8th?
I'll put it for September 8th.
All right, September 8th.
Just double checking, Judge, but that sounds good. Yeah, that's fine, Judge.
All right, September 8th. And you say there's 2 cases?
Yes, Judge.
All right.
There's 2 counts.
2 counts.
Well,
All right. Your plea deadline date has expired. You're set for jury trial on September 8th. What I can tell you is there may be someone who is an older case that is before you, but that's your date. If for some reason you are not in trial on that date, we'll put you as soon as possible. Do you have any questions?
So that's the last one?
Yes, September 8th. We're currently in trial, otherwise I would take you now. All right, thank you. All right, and council, has a acknowledgement of discovery already been completed?
Yes, sir.
All right, thank you. Thank you.
Maybe excuse me.
Yes.
I also have an Antonio Garcia.
All right, just give me one moment. Let me put this in the system. And what page is he on? Thank you.
Sorry.
Who's your other person?
Thank you.
Antonio Garcia. And it's also plea deadline date. We also need to.
They have it up here. Antonio Garcia.
I thought they put it up there, Judge.
Oh, I'm sorry, it is here. All right, he has a violation report
Yes, Judge.
that we need to address. Have you conferred with the state of the violation report?
found that, Judge.
All right. Sandra Gabriella Ramon?
Present on that, Judge.
Yes.
There was a slight issue. It's our first appearance today. I did receive a copy of the indictment. And it looks like she was enhanced to a first degree. I'm not on the first degree wheel.
Okay.
So I didn't know if the court needed
Just
to.
one moment.
Whether in the next few days, maybe in a couple, 2-3 weeks.
All right, Ms. Ferguson, I need a reset date on Ramon, 2 weeks, please.
Okay.
Is that good for you, counsel?
Yes, that's fine, thank you. It's.
And I'm sorry, your number, you said August 2026. All right, thank you. Joshua Albright.
We have reached an agreement. Is it possible we could take the plea on Friday?
Not Friday. We can do it today.
Uh,
All right, Norma, on that one, they have an agreement. David Dondelon.
would it be this morning or this afternoon?
Oh, we can do it now.
Oh, well, we haven't finished the paperwork.
All right, yep, we'll be here.
Hey, Judge. We're here.
Hello. So today is plea deadline date.
And just to let you know, I was conferring with Megan Galloway. She has not had a chance to tell us where she's at just yet. So if we could just have a minute.
Okay, sure.
Yeah, thank you.
Catherine? Yes.
This is on Zoom. She just wants to make sure if that's what she can contact.
No. All right, Catherine Marie Flores.
This is the lady you just appointed me to.
All right, Ms. Flores, I know this attorney has recently been appointed to you, and Mr. Kuntz, her attorney is ill, but she said she had no contact with her attorney. So to get you an attorney as quickly as possible, that's why he was appointed to represent you.
Okay, sounds
All
good.
right, and I know you all need some time to talk and you need to do discovery.
Correct. We've conferred. I've shown her the police reports already, and I told her we'll be getting the discovery hopefully soon, and we'll go from there.
All right, Ms. Ferguson, I need a 30-day reset on Flores, and we'll put it down as a discovery date.
Okay, thank you. Let me.
15th.
To 9:15. Okay.
Is that good for you, counsel?
That's perfect, Judge. Thank you.
All right.
Thank you.
Once she signs the reset form, she can be excused.
Thank you.
All right, Christina Lozano.
Yes. Right.
Are y'all ready to proceed?
Yes, Judge.
All right, can I get a file stamp for a plea, please? All right, the court is calling 2025 CR 006123 State versus Christina Lozano. Can I have parties announced?
Hunter Morris for the state.
And George Manning for the defense.
All right, just a moment.
Judge, I'm not saying anything.
Yes. All right, counsel, have you received all discovery?
Yes, I have, Your Honor.
Did you review it with your client?
We haven't reviewed it personally, Your Honor, but I discussed it with her.
All right, do you still wish to proceed?
Yes, Your Honor.
All right, the court will find that the state is in compliance with discovery. Ms. Lozano, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes.
All right, just one moment. Could I get a clip for this, please? A black one. Thank you. Counsel, do you waive the reading of the indictment?
Yes, I do, Your Honor.
State, are you proceeding on the indictment as presented?
Presenting on count 1, paragraph A, Judge.
Judge.
All right, Ms. Lozano, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with fraudulent use or possession of identifying information, 5 to 10 items against the elderly? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the The fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine? Did you understand?
Yes.
Just one moment. Let's go off the record. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Lozano, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 1, paragraph A. There's a $1,000 fine. The state is silent on your application for deferred adjudication. The state recommends community supervision. They're taking into consideration CC 734-399. There's to be restitution of $36.74 to Randolph Brooks Federal Credit Union. And that's to be payable to the victim in cause number 734-399. There's to be no contact with Deborah Finland or Lauren Thomas. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
Judge, just with clarification, the restitution to Randolph Brooks, that's in this cause. There's additional restitution to be determined in that cause, the CC cause.
All right, so additional restitution to be determined in CC 734-399.
Yes, Judge, for Ms. Thomas.
All right, and so the restitution for this specific case is only $36.74. All right. And did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Not to this date, Your Honor.
All right, outside the agreement, the state is recommending 150 hours of community service restitution and the MRT and the TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in count 1, paragraph A, how do you plea?
No contest.
State any evidence.
State tender states one attachments, Judge.
No objection, Your Honor.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. All right, so with regards to, do you have an amount that's due for this specific, for the case CC 734399?
I don't, Judge. It's a separate incident.
All right, when will you have that amount that's due?
I'll go after this judge and confer with the ADA over in County Court 15 and find out. So,
Well, I'm assuming it's not of a level that will put it at a felony amount.
no, Judge, within the week.
Okay, so do you all want to proceed with sentencing?
We're going,
Go ahead.
we're gonna request a PSI, Judge.
All right, that's gonna be 12 weeks.
Okay, Your Honor.
All right, so within 12 weeks, you all need to confer off docket. And the amount that you all agreed to for that other case, you need to come prepared to pay that. Do you understand?
Yes.
All right, Ms. Ferguson, I need a PSI and tap date, please, on Lozano.
October 14th.
All right, 10/14. And confer off docket on the amount that's due and make sure that amount, you have the money for that amount when you come to court.
Yes, Your
Thank
Honor.
you.
Excuse.
Yes, no, you need to talk to probation. Probation, if you could do a PSI and tap on Lozano, and it's set for October 14th. Thank you.
Thank you, Judge.
Thank you. Always good seeing you, Hunter.
Likewise, Judge.
Oh. Who's here on Albert Levine or Levine? Are y'all ready to proceed?
Yes, Your Honor.
Court is calling 2019 CR 5167 State versus Albert Levine. Could I have parties announce?
Ashley Jones for the state.
Roberto Ambrosino for the defense.
And are you Mr. Albert Levine or is it Levine?
Levine.
Levine?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? I'm going to need you to speak up so the court
Yes,
will
ma'am.
prepare. All right. Are you the same Albert Levine who was placed on deferred adjudication in 2019 CR 5167 for the offense of injury to a child bodily injury reckless on April 25th, 2022 for a period of 5 years? Is that you?
No, ma'am.
You're not that person?
Yes, I am, but I'm not the same person now, but yes.
Are you the same person who's on deferred adjudication
Yes,
for the offense of injury to a child bodily injury reckless? And you were placed on probation on April 25th, 2022. Is that you? For a period of 5 years, is that you?
yes, ma'am.
All right, state, you may proceed.
Yes, Your Honor, we are proceeding, a violation condition number 4 in the state's motion to supplement. And that is gonna be in Bear County, Texas.
Just 1 second. Did you review the supplemental motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
All right, does anyone have a supplemental for the court? Thank you. Thank you. All right, state, you may proceed.
Violation of condition number 4 in Bear County, Texas. The defendant, Officer Levine, did then and there fail to report to the supervision officer as directed for the months of September, October, November, and December in 2022 in violation of condition number 4.
How do you plead to that? True or not true?
And the state will waive the remaining violations.
Any objections to the state's waivers?
No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you to 2 years in the state jail facility, and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. That agreement is for 12 months in the state jail facility.
That is the agreement.
All right, has he done anything on probation?
Your Honor, our information is that he has absconded since 2022.
All right.
My understanding that Mr. Levine had experienced homelessness during some of that time. He's speaking with his mother-in-law who's in the courtroom. He also has some mental health issues and some disabilities that he's overcome that has made it difficult for him to find probation. But he hasn't been arrested in that time, and he takes responsibility. He's ready to put this plan.
So has he done anything on probation?
I don't. He's done very much in probation.
So he's done nothing.
That's correct.
All right, this is what the court is going to do. The court is going to find violation of condition number 4 true. The court is going to find you guilty.
You're right.
The court is going to revoke. The court is going to sentence you to 23 months in the state jail facility, give you credit for any time served. There's to be no unsupervised contact with minors. And there's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction and also a finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And counsel, I'll retain jurisdiction.
Okay, thank you.
All right, thank you. Yes,
May I please tell my family bye?
no. Well, let me tell you, I say no. I'm stepping outside of my lane. The deputies are in charge of security. I'm not, so you need to ask that question to them. Deputy Laura, he wants to say goodbye to his family. She said no. Thank you. Patrick Michael Cuellar. And where's Mr. Cuellar?
Coming up.
All right. All right, so he has a federal case. Is that federal case still pending?
Albert Crum is, I believe is on that, and he was here this morning. However, I think he had to go out of town and just to coordinate it. I'm not apt to do any, I mean, well, I know they don't want to do anything with it because of the fact stuff, but I believe that Scott McCrum would have more information on that, Judge. Unfortunately, he had to leave.
All right, and so the state does, I'm sorry, so the defense doesn't want to do anything because of the federal case that's out there. Does the state want to do anything with the federal case out there?
No.
All right, so that's an easy answer.
But there is an end in sight, Judge, because my understanding, unless I'm wrong, Scott McCrum said that there is a sentencing set at some point for the federal case.
It is not a sentencing, but they are going to be entering into a plea arrangement prior to September 29th.
Okay.
And
Do you know when your next federal date is?
the 29th of next month.
All right, so Norma, if you can set this in October, please.
Thank you.
Thank you, Judge.
Thank you.
You can set it at the beginning of the October.
Yeah, October 6th, that's Monday.
All right,
Should be.
October 6th.
Yes, ma'am, that should be fine.
All right, once you sign the reset form, you're excused, and thank you for dressing appropriately for court. All right, have a good rest of your day.
Thank you, Judge. Thank you.
Who is here on Noam Neelam? Noah Neelam?
Yes.
All right, where's your client?
I don't know, do.
All right, is he on bond?
Virtual.
All right. Deputy
I've had no contact with him, just said I don't know where he's at.
all right, let me do this. Ms. Abrams, Noah Neelam, has probation had any contact with him? Because the last I have was that he was supposed to be transferred to Williamson County.
I do believe that happened, Your Honor. It looks like there was he's in virtual booking, so there's a new charge out of Williamson County. I'm not sure if he's.
Yes, but according to the report from probation, that he is still in a group home, but evidently is being booked in Williamson County for not registering.
All right, so what I can tell everybody, I remember this case. I know you remember this case, and we've been trying to work with him. He has mental health issues. He has mental disabilities other than the mental health issues. He's young. And we have been trying to find placement for him where he can be around people that are similar to his age. But he's not here today, and you have no idea where he is.
I've had no contact with him, just I don't know what.
Yes.
I just have.
Well, he's on GPS, am I right? Because they say virtual booking, which means, does that mean he's on GPS, Deputy Laura? So what we need to do then is if he's been arrested for a warrant out of Williamson County, maybe he's not here because he's still in Williamson County and he's necessarily not able to appear here because he's in custody.
And the only information I have on him is his name and Williamson County, and that's it.
All right, so let's do this. Let's recall this. If no one objects, we'll recall this for Monday. I'm sorry, not Monday, Tuesday. In between now and then, let's see if where he's located.
If he's booked and bonded or.
Yes.
Yes.
So counsel, if you can check to see if he's in Williamson County, Norma, if we can recall this for Tuesday, Ms. Abrams, are you okay with recalling this for Tuesday? All right, so if we'll set this on, what is that, the 19th? Okay. Because counsel, as is, I don't even know if he knows about this setting. And if he's in custody, then has no way to show up. All right, is there anything else?
No.
All right, thank you.
Thank you.
The interpreter is here.
Okay. And who is the interpreter here for? Who did you say? Oscar Carrillo Hernandez. And I'm gonna need a 30-day reset for discovery, please.
I can do for 16.
Can I get one more day, cause I'm on vacation and,
When are you on vacation?
8:23 to 9:08, but probably gonna be till 9:10, but then I have some heavy cases when I get back, so I can just get one more day.
All right, and what day did you give me, Norma?
Basically 16.
All right, we can do it the 23rd.
23rd is perfect, thank you.
Norma, is the 23rd okay?
Yes.
All right, so you'll be here on discovery for September 23rd. Counsel, do you need immigration attorney or you would take care of that?
No, I'm gonna talk to him about that.
All right, so you'll be back on September 23rd for discovery. Do you have any questions, sir?
No.
All right, thank you. Do you need me to sign anything?
No, thank
All right,
you, Your Honor. Have a
thank
good day.
You too. And Norma, what page do you have him on?
He's on page 5.
All right, thank you.
No.
No, looking. Yes.
I know. I don't know exactly.
Antonio Garcia.
Present, ready.
And after Antonio Garcia, it will be Joe Lazama. All right, have you all addressed the violation report?
Judge, we conferred on that. There's an option that was given by pretrial services. And we would ask the court to accept that. We know that, as always, things are at the discretion of the court.
All right, so Mr. Garcia, it appears to the court that you have issues with your sobriety. So what do you need so that you can maintain your sobriety? What would help you?
I mean, when they asked me to sign up for the outpatient thing and
No. I mean, I know what they're asking you to do. My question is, what do you need to help you maintain your sobriety? Have you Have you given thought to that about what you would need?
Honestly, no, ma'am,
All right.
but.
So we're gonna try some different things
Yes.
because the maintaining of your sobriety is a part of your bond condition, right?
Yes, ma'am.
So have you done any type of sober support meetings, their AA meetings?
When I was when I was in prison, yes, I did cognitive, I did AA, SA,
All right, did that help you? Did you find that to be of help?
yes, ma'am.
All right, so this is what I'm going to do with regards to the violation report. I'm gonna continue on bond. You have the same conditions, but I'm gonna order outpatient treatment. I'll ask that the fees be waived for that.
Thank you, ma'am.
And I'm going to give you 7 days to comply with that because you desperately need that.
Yes.
And then I'm going to order daily sober support meetings.
The Zoom,
Yeah, but it needs to be every day. You understand? All right. So now, today is plea deadline date.
We've conferred, we do not have an agreement, so we need to move towards jury trial setting.
All right, Ms. Ferguson, we need a jury trial date. It's, criminal trial division.
I can do that September 8th.
Let me ask you this, just 1 second. All right, October 14th.
Sure. And we've done a discovery acknowledgement as well.
All right. All right, so your jury trial date is gonna be October 14th, and I'm gonna make that his jury trial date and his plea deadline date based upon the circumstances.
Yes, ma'am. Thank you.
Oh, and how was the movie?
It's good.
Okay, I may have to put that on my list.
Ms. Boyd, can I make one request or simply a comment? My job, I work at a battery distribution center. And for over a year, my lead was high. So they wouldn't let me do overtime. And the way I work second shift, which is 3 to 11.
Mhm.
So when they need people for overtime, either they'll call you, when somebody calls in, they either call me before or after, but pretrial is asking for 24-hour
Okay, let me just
notification.
tell you what, I will strongly consider that if
Yes, ma'am.
you start testing negative.
Thank you, ma'am.
So I'm gonna help you. Sometimes you need to maintain your sobriety, and you're really supposed to do your sobriety just for yourself, but sometimes you need that extra incentive. So here's that incentive.
Yes, ma'am.
I need you to show me some history or testing negative, then I'll strongly consider changing the GPS.
Yes, ma'am. Understood.
Okay? All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused. And go to a sober support meeting today, okay? All right,
Have a
thank
good
you.
day.
Thank you, Your Honor. Actually, Judge, the girls enjoyed it more than the boys now too.
Okay. Sure.
So we've got to be all and you can really one of them have never ever I don't know if you know other parts. I don't know if you want us to make. So I was just saying, can we leave and then I'll come back with her? Because, you know, I mean, we're not getting this done anytime soon. We don't have a waiver. Well, okay, but I don't have a file either.
Do y'all see Antonio out there? He is. All right, Alexander Rodriguez. All right, good morning. So this is Mr. Rodriguez?
Yes, Judge.
And you're asking for the court reporter's records to be provided
Yes, Judge.
and that your client is unable to afford
Yes,
the costs?
yes. And I'm prepared to put on testimony if you'd like.
All right, Mr. Rodriguez.
Your Honor.
Hi, do you have any money in a savings account?
No, ma'am.
All right, how long have you been in custody?
For over a year.
All right, the court will grant your request for the court reporter to pay for for the county to pay for his record for appeal.
Thank you, Judge.
All right, thank you. All right, Mr. Rodriguez, I'm sorry, Mrs. Giovinco, do you need to speak with him before I have them release him?
No, I did talk to him beforehand. Alex will be in touch.
Okay.
All right, you can let them know that we concluded the hearing, Mr. Rodriguez.
Yes, ma'am.
Thank you, Judge. You're welcome. All right, June Bright.
May I just inquire whether or not you have some people on Zoom? I'm waiting for some witnesses.
I have.
There should be a Violet Robinson.
I just have a Samsung, so it may be your witness. All right, June Bright from this side, council. All right, today. Is she entering a plea?
We're entering a plea, Judge, but we're gonna ask for a sentencing.
All right, could I have a sentencing date and could I have a file stamp for a plea, please? Court is calling 2025 CR 0028831 State versus June Bright. Could I have parties announced?
Megan Galloway for the state.
Ashley Morgan on behalf of the defense.
And are you Miss Bright?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Bright, did you review the application for community supervision with your attorney? Did you understand it?
Yes,
And did you sign it?
yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
We do waive the reading, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
yes,
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Bright, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes, ma'am.
Are you a U.S. citizen?
Yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine probated. State recommends community supervision, the ignition interlock, and 2-year driver's license suspension. Did you understand that to be your plea?
yes,
Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Proper states one in attachment.
No objection.
All right, did you review the waiver and consent to stipulation in testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. With regards to the offenses that make this a third-degree felony, there are different names attached to it. One is June L. Johnson. Are you June L. Johnson?
I was then, I was married.
All right. And then the other name is listed as June Lorraine Alcorn.
Yes,
Is that you as well?
yes,
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will set this for a sentencing on June 14th.
I believe it's October 14th.
I'm sorry, October 14th. See, your name is June. So the court will set it for October 14th. There's going to be a PSI, a TAP evaluation, and a referral to felony drug court. All right, probation will speak with you. Once you have your reset form, you are excused. Thank you.
Ms. Bright in the first bench.
And Deputy Laura, just let me know when it's here. Who's here on Joe Lazama?
Good morning, Your Honor.
Good morning. How are you doing?
I'm doing great, thank you.
And how's your wife?
She's doing a lot better, thank you.
Awesome. All right, there are no applications, correct?
That's correct.
Court is calling 2024 CR 008-905, State versus Joe A. Lazama. Could I have parties announced?
Megan Galloway for the state.
Michael J. Sawyer for the defendant.
And are you Mr. Lazama? I'm gonna need you to speak up so the court reporter can hear, okay?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lazama, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we move to proceed or waive the elderly enhancement and proceed on the lesser included offense of assault, bodily injury, the class A misdemeanor.
Any objection?
None, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
The state is proceeding on the lesser included offense of assault as a class A misdemeanor. The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lazama, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of a class A misdemeanor assault. Your punishment is to be assessed at 365 days in the Bexar County Jail, and there's a $1,000 fine. Did you understand that to be your plea?
Yeah. Yeah.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Did you sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that you can appeal or complain about are written motions that your attorney has filed and that I've made rulings on. Do you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, state, any evidence?
State offer states one in attachment.
Defense has no objection.
All right, and Mr. Lazama, have you understood everything that I've discussed with you so far?
Yes.
Do you have any questions about anything? You need to say yes or no.
No.
All right. State, you may be excused. Did you review this document
Yes.
that has the police report and all of the evidence in it?
Yes.
Did you understand it?
Yes. Yes.
Now, you still can have a jury trial if you want to. But if you don't want to go forward with the jury trial, then the court is going to review this document and the state is not going to call any witnesses. Do you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
I believe everything the court needs to know is contained in the paperwork.
All right, so why are you doing this? Is there an issue that you have? Are you able to, yes,
If I may.
please tell me.
He was in the state facility for over a year and it's just been recently restored back.
Ah. All right, so here's the thing. You're gonna have to make sure that you stay on your medications, you understand?
Yes.
And you can't go around, the river walk and push people, you understand?
Yes.
All right, the court is gonna find you guilty. The court is gonna sentence you to 365 days in the Bexar County Jail, give you credit for any time served. There's $1,000 fine, time and money to run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a bargain agreement, because I followed your plea and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. When you're released from custody, you need to go straight to the Center for Healthcare Services. Do you understand?
Yes.
If you cannot find that, or if you can't remember, just come back to court and we'll get someone to make sure you make it there safely, okay?
Okay.
All right, thank you. Good luck to you.
No, I saw, I have that excuse.
Yes,
Have a good day, Your Honor.
you too. Paul Ragsdale. Hi.
I feel like I won the lottery.
All right, so everyone can know, let me give you the lineup. After Paul Ragsdale, it will be Ricardo Reyes, Simon Garza, Feliciana Morrow, Kelly Aguero, Lacey Schronk, Jacob Aguero, and Rodolfo Briceño. Right, is there an application?
There's not.
Okay. Court is calling 2025 CR 009059, State versus Paul Ragsdale. Could I have parties announced?
Lauren Espinoza for the state.
Roberto Ambrosino for the defense.
And are you Mr. Ragsdale?
Correct, Your Honor.
Counsel, have you received all discovery with your client? I'm sorry, all discovery from the state, and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Sir, did you review the true bill of indictment with your attorney? Did you understand it?
Correct, Your Honor.
Yes or no?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the enhancement allegation and proceed solely on the state jail felony offense.
No objection.
All right, sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Ragsdale, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Court, yes. Your
Are
Honor.
you a U.S. citizen?
Yes. Your
Court
Honor.
will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, punishment is to be assessed at 104 days in the Bexar County Jail under 1244. There's a $500 fine. State is taking in consideration 2025 CC 006812. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
There have not.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, off the record for a moment. State, could you call Miss? All right, if you all review this, please. All right, after reviewing State's Exhibits 1 and attachments, the court will find I'm sorry, how do you plea?
No contest, Your Honor.
No contest. And state you're offering State's Exhibits 1 and attachments?
No objection.
All right, and you've reviewed those?
Yes, Your Honor.
All right. And you reviewed those with your attorney and you understand it?
Yes, Your Honor.
All right, you still have a right to have a jury trial. So with the state offering this evidence, that means they're not going to bring any witnesses in to testify to prove up their case. They're going to ask that the court review their exhibits and prove up their case without witnesses. Do you understand?
Yes, Your Honor.
All right, court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just ask you follow.
All right, this is what the court will do. As previously stated, the court will find you guilty. The court will sentence you to 104 days in the Bexar County Jail under 1244. There's a $500 fine. Time and money will run concurrently. Taking consideration 2025 CC 006812, and there's to be no contact with the Home Depot. Did you understand? Well, no, yes or no?
Yes.
Right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. If you have a drug or alcohol problem, there are plenty of places that can help you. If you don't get the help, what's going to end up happening is you're going to be in and out of jail, or worst case scenario, the last time you use may be the last time you use, and somebody will have to identify your body. So if you can't find a sober support living transitional house, or you can't find somebody to help you with your addictions, if I'm still here, you can come back here and I will pick up the phone and find a place for you. Do you understand?
Yes, I do.
All right, good luck to you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Ricardo Reyes. What this? All right, could I see that question again, please?
You have reviewed it.
Yes.
We believe it's just, you have all the line evidence before you.
All right. So I'm sorry, just,
okay.
just stand to the side. Let me see if I can find that. All right, counsel, can you have your client back in?
Yes, Your Honor, he's right there.
All right, if you can come forward, please. And sir, if you could just stand to the side. All right, the court has received the following question from the jury. During a portion of the state's questioning of a, oh, I'm so sorry. You have the cause number?
Yes.
All right, we're back on the record in 2023 CR 8868, State versus Samuel Bock. Could I have parties announced?
Megan Galloway for the state.
Jody Sawyers for the defense with Samuel Bock.
All right, the court has received a question from the jury. The question is, during a portion of the state's questioning of a witness, a law was read about right-of-way that referenced the driver has right-of-way only when driving in a lawful manner. Can we see how that law exactly reads and what is the definition of it? Have both parties had a chance to review the question?
Yes, Your Honor.
Yes, Your Honor.
All right, any objection to the following supplemental charge? With reference to your inquiry, you have all the law before you. Please continue your deliberations.
No objection.
No objection.
All right, any objection to the court sending the question and answer back to the jury?
No, Your Honor.
All right, thank you. All right, the court is calling 2025 CR 005931, State versus Ricardo Reyes. Could I have parties announced?
Rick Pena for the state of Texas.
James Tochi for Mr. Reyes, Judge.
And are you Mr. Reyes?
Yes, Your Honor.
Counsel, have you received all discovery in this case and did you review it with your client?
Yes, Judge.
The court will find that the state is in compliance with discovery. And probation, this is an application. Mr. Reyes, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault family household member with a previous conviction as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, are you all applying for deferred adjudication?
Yes, Judge.
All right, did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a US citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine. State opposes your application for deferred adjudication. They're taking in consideration 2025 CR 005929, 2025 CR 005927. There's an affirmative finding of family violence and no contact with the complainant. Did you understand that to be your plea?
No,
There's one more thing, Your Honor. We also are recommending community supervision.
Yes, and they're recommending community supervision.
That is our deal, yes.
All right, is that your understanding of the plea?
yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be 100 hours community service restitution, BIPP, and TAP evaluation, and follow all recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. At this time, state will present the evidence, takes exhibit 1 with all attachments.
Without objection, Judge.
All right, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Counsel, we can bring this back in a couple of weeks, or either it's going to be 8 to 12 weeks for sentencing for the PSI and TAP.
I would be okay with the shorter term, Judge.
All right, Norma, could you give me a 2-week reset for sentencing? All right, let me give you a 2-week.
I have one writer I would like to.
All right, do you want to call this back for August 26th?
No,
All right, what date are you looking at?
the 28th would be a better day for me,
All right,
Thursday.
Can we do that's a Wednesday?
no, August 28th is a Thursday. No problem. Is August 28th okay for everyone?
Yes, Your Honor.
Yes, Judge.
And are you waiving PSI?
If the court doesn't need a PSI, we would be, are you want to do it today?
No,
Is that-
I mean, I thought you were gonna have witnesses that you want me to hear
No,
from.
ma'am, I do not anticipate.
All right,
calling
then
you.
if you're applying for deferred adjudication, he may need a TAP evaluation.
Yes, ma'am.
All right, so what we'll do, can we recall this back for October 14th? Bashan, is that enough time?
Yes, sir.
All right, so it'll be October 14th for sentencing. I just remain in the courtroom and we'll give you a reset
Judge,
form.
one item, and I haven't filed a motion, but not contemplated by the plea bargain. He is on a pretrial GPS full house.
Mhm.
I don't know if I filed a motion, if the court would allow the removal of it. He would like to work and can work. He's trapped at home.
All right, I'm not gonna allow the removal of it, but if you all want to file a motion, I'll hear whatever you want to bring and he can appear by Zoom.
All right, thank you, Judge.
You're welcome.
PSI and TAP is this TAP?
PSI and TAP. All right, guys, any update?
Well, I don't know if that's.
All right, thank you.
Oh.
All right, who's here on Simon Garza? Oh, is this on the docket today?
Yes, Judge.
All right, where's your client?
Right here.
Hello.
It's on the docket and we have a motion to appoint an investigator.
All right, are you retained?
Yes, Judge.
All right. You want to raise your right hand for me, please? Do solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, and this is cause number 2025 CR 004128. State your name for the record.
Simon Garza.
All right.
Thank you, Judge. Simon, can you tell the judge, first of all, how long were you in custody?
I was in custody for about a month and a half.
Okay. And while you were in custody, or before you were in custody, were you working?
I was about to start my job.
Where,
I was about to start my job.
and where were you gonna work?
I was gonna work at Texas San Antonio Orthopedic Group.
Was there something significant that had happened in your life prior to getting arrested?
I had just finished my medical assisting certification and my phlebotomy certification.
Okay. And your what certification?
Phlebotomy.
And since getting out of jail, do you have a job?
Since getting out of jail, I have not gotten a job.
Who paid for our services as your attorney?
My fiance.
Okay. Your
Fiance.
Do you and your fiance live together?
No.
Okay. And do either of you have any assets or anything that you could sell?
No.
Okay. Does your fiance have any additional funds to be able to pay for an investigator in your case?
No.
Do you have any savings or any funds that you can use to pay for an investigator in your case?
No.
Do you currently have any income coming in?
I have no income coming in.
I'll pass the witness.
Okay. So with regards to your motion, this doesn't really tell me what they're intending to do. So if you could have them place that in there,
Okay.
then I will have an idea of what the amount should be.
Okay.
All right, so with regards to this, where are we on discovery?
I believe we have everything, Judge, but our investigator did just get appointed, or no, I'm sorry.
Mhm.
Did she get appointed? You know, I thought it was granted. Now I'm confused.
Okay.
I guess that's not, it didn't, because that's why we're here. She hasn't been able to get started to know if there's anything else we want to ask the state for. But I believe everything that they've given us, we have.
All right. I need a 30-day reset on this case for for the state to tender an offer.
September 16th.
All right, once you sign the reset form, you excuse. Thank you for dressing appropriately for court, okay? Thank you.
My name Marissa Giovenco, Giovenco.
Here.
I can't read the judge, I'm sorry. Thank you.
Marissa, you go. I need to for you guys to send a reason. Got it. So you'll get a copy.
All right, everyone, we're going to take a brief recess.